Yeah, I guess we have now 32 people. Well, hello everyone, and uh, the audience is still coming in, and so I will wait for just 1 minute and to start the program. Okay, we should get started. Welcome to the second installment of the Scan the Globe series. And I'm the president of the AIPPI International, Shoichi Okuyama, and I'm here to say that the myself and several other people in the bureau masterminded this program. That's why I'm giving you welcome remarks. And the most important thing that I have to say is that well, thank you for the those people who organized the uh, this event and also the speakers who spent huge amount of time preparing presentations and giving presentation. This series will go on. We will have another installment hopefully soon enough, and the plans are lined up. So stay tuned, and I hope you have enjoyable time today's program. Thank you very much.
Thank you very much, Mr. Okuyama, and thank you, AIPPI and Judith, for running these Scan the Globe webinar series. It's been a great experience working with AIPPI International and the other AIPPI chapters in the region, who are all represented here today. For those of you who don't know me, my name is Huda Barakat. I am the president of the AIPPI UAE chapter, and it really has been a pleasure to work with everyone. As you can imagine, in the time available, we couldn't cover the whole Middle East, but what we have tried to do is cover at least a sample from Egypt to Jordan to Saudi Arabia to the UAE. And we hope you will enjoy this regional journey through the Middle East with us. We're extremely lucky today to have a distinguished panel of speakers who will share a summary of the IP laws and practice, including enforcement, some specifics, statistics where possible. If you've worked in the region, you'll know that statistics aren't always the easiest. But if I may, before we kind of start full on, we'd like to go through some housekeeping, and then I will introduce the speakers. Thank you. So today's event is a webinar, as you all know, and you will only be able to see and hear the speakers. There will be a short Q&A session after each presentation. And I do say short because the speakers are trying to obviously fit in a lot in a very short period of time. But we have allowed the Q&A because we feel that's very important, and we'll bring out some of the key issues. The questions to the speakers should please be submitted via the Q&A function on your screen. So if you click that and type a message, Ms. Judith Willard will kindly kind of go through those during the Q&A for each speaker. The chat function can be used for general comments and feedback, but please stick to the questions on the Q&A function, just so we're clear something is a question. For technical problems, please send a message via the chat function to AIPPI events. You'll see them listed when you go to the message. And the recording of the slides from today will be available upon request. So if you would like the slides, if you'd like the recording, please email events@aippi.org. So no need to kind of actively take notes if unless you would like to, but the slides will be available, as will the recording. So without further ado, I think you came to hear the distinguished speakers, not us so much. We have, as I said, distinguished speakers, Dina Amr Adib from AIPPI Egypt, Mr. Mohammed Masri from AIPPI Jordan, Ms. Shadia Awad from APIMAF, and Mr. Munir Subah from AIPPI UAE. What I'll do is I'll introduce each speaker before they speak, just so you know exactly who will be speaking to you, and I'll keep it short because they're all have very long CVs and very impressive backgrounds. So without further ado, and just to get us going, because I think we have a lot to cover, we'll start with Ms. Dina Adib, who is representing AIPPI Egypt and is a partner at Eldib & Co., headquartered in Egypt, and serves as the head of their trademark department. She has over a decade of experience within the field, with a particular focus on IP protection, brand protection, and litigation in the North African countries. So without further ado, it's my pleasure to ask Dina to share her slides and speak to us. Thank you, Dina.
Thank you, and thank you for that wonderful introduction. I'm going to kick us off today covering Egypt. There's obviously a lot to cover and not so much time to cover it, so I'll just get right to it. First, I'm going to go over some just basic information and statistics, and then I'm going to cover some more important must-knows regarding the Egyptian landscape. First things first, Egypt joined the WIPO in 1975. It's party to numerous treaties and agreements, but the most notable of which are obviously the Hague Agreement for Industrial Designs, Madrid Agreement covering trademarks, Paris Convention for Industrial Property, Berne Convention in terms of copyrights, the TRIPS agreements for software, and the PCT. The law that governs IP in Egypt is the Law of 82 for 2002. It is comprised of 4 books, the first covering patents and utility models, the second trademarks, GIs, and industrial designs, the third is for copyrights and related rights, and the fourth is plant varieties. So if we have a quick look at some patent statistics, in terms of applications filed, we'll see that there's pretty much a 60-40 split, with the majority of patents being filed by non-Egyptians. There's about 2,000 patents filed a year, but however, when we come to grants, and this pie chart shows grants in the past 10 years, we'll find that the applications are mostly granted to foreign applicants, with Egyptian applicants only having about 20% of the granted applications. This is an overview of the grant by nationality. Also, Egyptian applicants only having, like I said before, less than 20% of the granted applications. This slide covers patents filed by women. We'll see that obviously there aren't so many female-owned patents, but we'll see that there are women on research teams, and that women are part of about approximately 400 out of the 2,000 applications filed a year. So the examination phase in Egypt is quite long, especially in comparison to other jurisdictions. For most patents, it takes about 2.5 years for an office action to issue. For pharmaceutical patents, that's actually double. It takes about 5 years for an OA to issue. And the reason for that being is that there's substantially more patent applications that are being filed in Egypt. Pharma patents that are being filed in Egypt. The exception to this would be the PPH, or the Patent Prosecution Highway, whereby Chinese and Japanese patents that are granted within those two jurisdictions can be filed and sort of skip the queue, so to say, being examined prior or out of turn. They get priority, and if there have been accepted in either of those two jurisdictions, they become automatically accepted in Egypt, provided that they fulfill the local patentability criterion, which is it must be of practical use, it must show an element of novelty, have an inventive step, and provide a new sort of characteristic which is not known in the technical field. And finally, it must be have industrial applicability. So what cannot be granted is, a big one is software. More and more jurisdictions are having software patents. Egypt still does not accept software patents. There's a way to bypass that and go through the Ministry of Telecommunications, where you can deposit code and have that registered. But in terms of enforceability, I wouldn't say that it's quite the strongest as of yet. So software patents aren't accepted, methods, Swiss claims, and also double patenting is not available. Lastly, we'll just have I have a small chart on the difference between the patents and utility models. Utility models don't need to have an inventive step. They can be minor improvements, and the term of protection in Egypt is 7 years as opposed to 20 for the patents. Moving on to trademarks, and this is my area of expertise. So it's the one that I find quite interesting to me, because it's very important to highlight that the rights are enforceable. A lot of people worry that, this is a third world country or a developing country, and it's chaotic in terms of its systems, but the rights are enforceable, and we've been seeing really good results. So here are the number of statistics filed by year. Approximately 30,000 applications filed a year, a little bit less than 10,000 registrations. A lot of applications are, it takes about 18 months for them to be reviewed. So sometimes it takes, so the numbers that we see are typically spillover from the previous years. What can be accepted? Two-dimensional marks, word marks. We still don't have any criteria or examination in place for 3D marks, shape, olfactory, or sound marks. And typically the examination just is based on the distinctiveness, examined registered trademarks. So like I said, what I like about this sector is that it is very enforceable. If we look at statistics that have been issued by the European Commission, we'll notice that Egypt is one of the top 10 manufacturers and producers of counterfeit goods. And while that might not sound very high, we're actually the 5th biggest producer after China, Hong Kong, Vietnam, and Turkey. The rest of the world only produces 4%. So Egypt alone is making half of that amount. So IP rights are locally enforceable if registrations are in place or the client has recognized rights by way of an international registration with extension to Egypt. There are a lot of options, including inland actions, actions before the free zones, and actions that can be taken against products in transit. The most basic of which are filing oppositions against published trademarks which infringe on their rights, or sending cease and desist letters via court bailiffs. The two main enforcement routes are the civil action and the criminal action. We've seen probably more favorable and speedier results with criminal actions, whereby firms and clients work with the Supply Investigation Unit or the Commercial Fraud Department to conduct raids against infringers. And those results are referred to the DA, who examines the report and in turn refers it to the court for further prosecution if he finds that it has a basis. Just a quick note on GIs, while it has a hefty mention, in the law of 2002. To date, we still have no systems in place for the registrations of GIs in Egypt. Here I have some just industrial design statistic, about 2,000 filed a year. Approximately a quarter of those are proceed to grants. We'll move on to copyrights. And unfortunately, we were unable to get any concrete statistics on the copyrights as filed. I believe the main reason would be that because Egypt is a party to the Berne Convention, local registration is not required and can still be enforceable based on from the date of inception, which is protected for the author's lifetime plus 50 years. The fourth book is the plant varieties, and while this might not be the largest or most robust field of IP, it's gaining a lot of traction in Egypt these days. If we look at the stats, we'll see that there's only, between 70 and 80 filed a year at most, with the grants also hovering around the same level. You'll notice that the grants might be higher than the applications in some years, and that's just due to the examination period, whereby it takes either 1 calendar year or 2 planting seasons for the examination to take place. Egypt is also a party to the UPOV since 2019, which means that while the examination is taking place, the plant variety is protected. For grapes and tree varieties, it's protected for 25 years, and then all other plant varieties are protected for 20 years from the date of grant. And then this is quite an interesting case, more of a landmark case, to be quite honest. An action was brought forth by Grappa Varieties Limited before the Economic Court in Beni Suef against a plant that was farm that was planting unlicensed early sweet grapes. The court ruled that in the entirety of 11 acres of vines and their seedlings be uprooted. And this really marks the first time that an action of this sort has taken place in Egypt. And based on this, we really expect to see an uptick in filings because it has been proven that PVs are enforceable. Now I'll just highlight a couple matters of note that are interesting for anyone who is going to do business or has any IP vested interest in Egypt. The first is GOIC registration. It's not new, but it's relatively still gaining traction. There's a ministerial decree of 2016, which requires that foreign companies be registered before the GOIC to be able to export products into Egypt. And one of the documentary requirements is the existence of a trademark registration within Egypt or an international registration with extension to Egypt. The interesting thing about this is that now anybody who is hoping to get a GOIC registration and export product into Egypt must have registered trademark rights. And this is obviously really important because it further legitimizes the standing of the registration certificate. The other latest update in the space is the National Strategy for Intellectual Property. This is a local strategy that was introduced by the Egyptian Prime Minister Mustafa Madbouli in September 2022. He has formulated a specialized committee to draft a national strategy for IP, which aims to realize the governance of institutional structure of IP and establish a national apparatus. What we're seeing is that there will be a review of existing legislations, including those in the health sector. They are going to promote the use of IP in scientific research. One of the other pillars is the raising of awareness of intellectual property rights for consumers and business owners in Egypt. And this strategy is supposed to be completed by 2027. Right now, there are 9 different bodies whereby you can get IP protection. And one of the main goals of this strategy would be to consolidate all the IP offices under one roof at the new administrative capital that's being built east of Cairo. Thank you.
Thank you very much, Dina. And I encourage everybody to use the Q&A function to ask questions. We have already one question, and that is, if a local factory sells counterfeit products to an African countries without having them sold in Egypt, is there a way to act? And if so, what kind of action?
Okay, so the question that I'm getting is it possible to take action against a company that is locally producing an infringing product, but does not sell the product in Egypt?
Yes.
The answer to that is absolutely yes. So once it doesn't matter where the product is sold, once this source is located in Egypt and the proprietor has registered rights within the jurisdiction, they are able to take either of the two inland actions, which is either a civil action or a criminal action, obviously based on the type of counterfeit good and its production basis and the liabilities that the proprietor wants to hold the factory accountable for. If they do not have registrations in Egypt, it would most probably be worth having a customs recordal in the African country to which it's being exported. And hopefully at that point, it could be stopped at the ports. But in Egypt, as long as there's a registered right, they can take action whether or not the product is being sold locally.
Thank you for that answer. And then I have one more question from Michael from Switzerland. What is Egypt doing for open access of patents via API?
I'm not sure what API is.
Okay, maybe if Michael, if you are still around and can clarify, we still have a moment to go. That would have been then it. Yeah, online access to data.
Is that in terms of publishable rights? The publication of rights?
Online access to data for application, exactly, and digitalization.
Well, the patent system has moved to an online system as opposed to all other entities which are still operating on paper-based systems. In terms of granting worldwide access whereby anybody in the world can see patents that have been filed online, I'm not sure that there have been steps taken in that regard.
Okay. Then thank you very much for answering also these questions. And I get even here a reply saying, great, thank you. So all covered. Thanks a lot, Dina, for the presentation, but also then for answering the questions.
Thank you. Of course, my pleasure.
Thank you, Judith. Thank you, Dina. That was a great kind of talk through the issues around Egypt and the laws, etc. Next, we travel through to Jordan, and we're lucky to have Mr. Mohammed Al-Masri representing AIPPI Jordan. Mohammed is a shareholder and the country manager at the Saba Jordan office. As a lawyer and intellectual property expert with more than 20 years of experience, Mohammed provides IP, legal, and strategic advice to clients based on best financial and legal practices in Jordan and the MENA region. Please, Faddal Mohammed. Thank you so much.
Thank you. Sorry. I would like first to thank Judith and Huda for organizing this event, and thanks to all attendees. I will try in brief to provide a summary about the IP system in Jordan. Starting with the treaties, Jordan is part of the following treaties: Paris Convention, Nice Agreement, Vienna Agreement, Berne Convention, Budapest Treaty, WIPO, WTO, and UPOV for sure. With respect to facts about trademarks and patents in Jordan, I will start with the trademarks. In Jordan, the 11th edition of NIST classification for goods and services is adopted. E-filing system is applied under continuous development and updates as from several years. We are trying our best to reach a better position with the e-filing system in Jordan by avoiding the delays and mistakes that we are facing sometimes. With respect to trademarks applications, rejection decisions, the trademark applications are examined on formal and absolute grounds. According to the Trademark Office practice, in case an office action is issued against a trademark application and the reply is filed, recently the Trademark Office started to issue a final rejection decision that will be subject to appeal only in front of the administrative court, which means that all applicants and agents should be very careful when replying to office actions in Jordan, as the same might end with having a final rejection decision. When the trademark is accepted, same is published at the electronically issued official gazette at the IPPD website on monthly basis, and the same will be subject to opposition within 3 months as from the publication date. The current time frame for trademark registration in Jordan is 12 to 14 months. At the beginning of 2022, this period or the time frame was shorter, but after that, we started to see backlog at the Trademark Office and ended with 12 to 14 months. As for the renewal term, it is 10 years with 1 year grace period, and the renewal application can be filed within 2 to 3 months prior to the expiry date, as per the current practice adopted by the Trademark Office in order to arrange the filing number of renewals. As for patents, patents application can be filed in Jordan through either through Paris Convention or PCT, noting that same requirements are needed, with the exception of the time frame or the filing period for both of them, as it will be 12 months for the conventional applications and 30 months for the PCT as from the first priority date. As for the requirements of filing for both PCT and conventional applications, such as form number 4, which is still a problem for many of the applicants, as deed of assignments are not accepted against form number 4, as well as power of attorney, certain corporation. All of these documents should be submitted in both Arabic and English. And if the documents is in other than English, an English translation thereof is required to be provided, provided that the documents should be submitted within 60 days from the filing date of the patent application, with the possibility for sure to obtain extension on time, while the minimum filing requirements, including the English patent application, inventors and applicants' details, along with the Arabic title and abstract, must be available at the time of filing. For the substantive examination, the same is applied to all applications filed after December 9, 2018 through Paris Convention or PCT, and the related fees become due once the application completes all its filing requirements. However, the Jordanian Patent Office is still requesting from applicants to support their Jordanian applications with the outcome of the granted applications in other jurisdictions, such as the European Patent Office or USPTO, in order to facilitate the examination in Jordan. For sure, as elsewhere, amendments of patent specifications is possible, provided that the same is filed before the acceptance of the patent, and that the amendment doesn't change the essence of the invention that has been disclosed as in the original application. As well, the original applications can also be filed in Jordan before the acceptance of the original patent application and bearing the original filing date. Upon fulfilling the needed requirements and submitting all the required documents, paying the required fees, PCT and conventional applications will be published in the official gazette, so that same will be open for opposition for 3 months thereafter. If no oppositions are filed, the relevant letters patent will be granted after that. As for the annuities, annuities for conventional applications can be paid optionally on annual basis, while the application is still pending, calculated based on the national filing date. And in other words, all accumulated annuities will be due for payment upon the grant and the payment of the final registration fees for the conventional applications, with a grace period of 6 months, subject to payment of surcharge. As for the BCT, all annuities are mandatory to be paid annually from the international filing date, with a grace period as well of 6 months, subject to payment of surcharge. The term of patent protection in Jordan is 20 years as from the filing date for conventional applications, and 20 years as from the international filing date for BCT applications. Statistics about trademarks, patents, and designs in Jordan, I have depended on the information provided at the website of the IPPD, and according to such numbers, an increase on the filing numbers of trademarks, patents occurred during the year 2021. I believe that part of such increase is related to the delayed filings during the COVID-19 outbreak, and the other part is related mainly to the increased interest in the Jordanian market in different sectors such as retail, FMCG, tech, and pharma or medical sectors. As we can see in the year 2021, the number of filed trademark applications reached 7,400, if compared with around 6,000 applications in the year 2022. As for the numbers of the applications filed in the year 2022, same are not available yet, but for sure we will be able to provide, hopefully through any future webinars. Now I will talk about the IP litigation and enforcement from legal and admin perspectives in Jordan. Jordanian laws provided for the enforcement of IP rights through the initiation of legal actions before the concerned courts. Mainly the related articles were provided in the trademarks law, penal law, in addition to other related laws such as the unfair competition law. Customs notification of suspected shipment is a good tool as well to stop the infringing products, while due to the limited quantities in most of the cases, clients are reluctant to initiate legal actions and therefore prefer having the matter transferred to GISMO in order to handle the matter administratively in an attempt to have infringing product destroyed or re-exported. For sure, having the related suspected product re-exported is not the ideal solution or the best option for the clients, but this is the max that can be done in case the client decided not to initiate the legal action in front of the court. Admin actions through or by GISMO are done for products in the Jordanian markets as well, but with limitations in respect of obtaining details of the infringing parties for the cases initiated by GISMO, and for a clear outcome of the complaints filed by the IP owners, which means that after filing this complaint by the IPR owner, no clear confirmation of the conducted rate or the quantities or the details of the distributor or importer will be provided, which is sometimes will be frustrating for the clients in case that they would like to link cases between countries. As for the customs recordation in front of the Jordanian customs, same is possible in front of the Jordan National Customs as well as the customs of the Aqaba Special Economic Zone Authority, ASIZA, and recommended in an attempt to have the customs official more alerted of suspected products, which through our practice proved that it's a good tool to assist in stopping such infringing products. As for me, I believe that we have some needed actions to be taken through the Jordanian chapter as well as by all IP practitioners in Jordan. We need to proceed with conducting intellectual property awareness sessions for schools, universities, technical institutes, chambers of commerce and industry, judicial authority, As raising the awareness of the IP is much needed in order to have the level of IP knowledge is to the needed level for taking actions in front of the courts or having the community supportive to the IP right holders. In addition, it is important to conduct advocacy meetings with the related authorities and stakeholders in an attempt to develop and improve the IP protection and enforcement work process, such as the DIPP, Customs, GISMO, IPR Police Section, which will facilitate the process of having such enforcement actions dealt in with more priority and with a faster way. And thank you very much. And I will be happy to answer any of your questions.
Thank you very much, Mohammed, for that concise
welcome,
presentation. And questions are floating in. So starting with the first one, that we have heard about Jordan joining Madrid for over 3 years now. Do you think they will join? And if so, when? Here, the participant is looking for your assessment based on the knowledge of the country.
Actually, joining Madrid system is an old story in Jordan, but till now there is nothing confirmed. But as all of us can see, it's coming to all neighboring countries, so that we will soon reach it. But as for now, there is nothing confirmed by the government, and no one disclosed any information about joining Madrid for the time being. For me, I still believe that in Jordan, it's still early to join Madrid system, as the trademark office in Jordan is still in need to develop their work process in a better way to be able to receive the international filings in parallel with the local applications.
Lovely. Thank you very much for your assessment.
You are most welcome.
Moving on, one question with regards to patents. Is there any patent linkage system in Jordan for pharmaceutical patents related to approved medical products like the Orange Book in the US, etc.?
Unfortunately, there is no patent linkage in Jordan, and the GFDA, which is responsible for the registration of all pharmaceuticals, are independent from the patent office, and there is no relation between both parties. So yes, there is no patent linkage in Jordan, and the same might be needed in order to have both parties acting in a harmonized way.
Right. So last question for now, which I can see here, but I still encourage people to put in questions.
Sure.
The next one is coming digitalization. So how digitalized are the IP systems? So meaning, is the patent filing system done on paper or via online software?
As for the filing of trademarks and patents, and mainly according to the question with respect to patents, all filings are done through the online portal of the patent office for all the new applications. With respect to the old applications, we are still in need to deal with such applications with paperwork, but for all the new applications, all are done through the portal of the patent office, so fully digitalized.
Right. Thank you very, very much for answering the questions, but also to all participants for having these questions. And obviously then, Mohammed, thanks a lot for your presentation.
Thank you.
Thank you, Judith. Thank you very much, Mohammed. Great presentation. Without further ado, we'll move a little bit to the east. We move to Saudi Arabia, where we have Ms. Shadia Ahmed Awad representing APIMAF, who is our regional group, and she will speak to us about Saudi Arabia. Shadia is a patent expert at Bayanat IP. As a patent expert with 25 years of experience, Shadia is experienced in drafting patent specifications and claims and managing the prosecution and registration of patents and designs in the MENA region and North Africa. Without further ado, تفضلي Shadia. Thank you very much.
Thank you very much. First of all, I need to confirm that you can see my presentation.
Yes, but not yet in presentation mode. Yes.
Okay. First of all, I would like to thank you very much for giving me such opportunity to participate in this event today. I would like today to briefly talk about the Saudi territory and the recent changes and updates in the IB systems. To begin with, I would like to talk firstly about Saudi Arabia, which is officially known as the Kingdom of Saudi Arabia. It is one of the largest oil producers. It is the second largest country in the Arab world and the fifth largest country in the world. With more young population, Saudi is on the front of being the under-standardized economy. Sorry, but I think there is some technical issue. Can I stop now, please? Yeah.
Nadia, do you want us to share from the background? I can't hear you. Nadia?
I think I have some technical issue, sorry. Can I postpone after Mr. Munir?
We can do that as well. The alternative would be that we see your presentation, by the way. If you go on the slideshow again.
Okay, can you see my presentation?
Yes.
Yeah, okay. To begin with, I would like to give a brief overview about Saudi Arabia and its importance in the region as a focus of attention for investors. Saudi Arabia is officially known as the Kingdom of Saudi Arabia. It is one of the most important countries in the Middle East and the fifth largest country in Asia. Such importance is attributed to the fact that Saudi Arabia is one of the largest reserves of natural gas in the Arabian Gulf and always seeks in its development plans to diversify its sources of economic production, supporting the growth of the private sector and providing job opportunities for Saudi youth by enhancing the contributions of the private sector and attracting foreign capital to support investment projects.
But yet, sorry to interrupt, would you mind putting on presentation mode? Yes. Yes, perfect, thank you.
Okay. On the other hand, with the aim of reducing dependence on oil as major resource of the national economy, the Saudi Vision 2030, approved by the Council of Ministers on 25 April 2016 as a strategic framework and reform program that seeks to diversify the national economy, sets out some of and number of objectives, some of which are directly enabled by intellectual property. Now I need to talk about outline of IB systems. Saudi Arabia is committed to building a culture of IP and to strengthening the enforcement of IP rights in the country to enable innovators to leverage the economic value and of their intangible assets. The common types of IP rights are patents, which protect inventions and new processes, trademarks, which protect logos and words and other branding, copyright, which protects art and writing, music, film, and registered design, which protect the visual design. Also, the circuit layout rights and plant breeders' rights. About the IP laws in Saudi Arabia, there are the law of patents, layout designs of integrated circuits, okay, which is issued in 2004 and entered into force on September 6, 2004. And also the other law is the law of a trademark, which is issued on 7 September 2002. Okay, Saudi policymakers have worked to extend and strengthen the national IP systems. In 1982, Saudi Arabia joined the World Intellectual Property Organization, WIPO, and has signed up a number of WIPO international treaties. Such of these treaties are the Berne Convention for the Protection of Literary and Artistic Works, also the Ricardo Agreement establishing an international classification of industrial designs, and also the Marrakesh Treaty to facilitate access of published works for persons who are blind and visually impaired. Also the Paris Convention, the Patent Treaty, Cooperation, and the Patent Law Treaty, and also the Vienna Agreement establishing an international classification of figurative elements of trademark. It should be noted that in the past, there were 3 governmental bodies which had the authority in Saudi Arabia to protect and enforce the intellectual property rights. The 3 are Ministry of Commerce and Industry for trademarks, the Ministry of Culture and Information for copyrights, and King Abdulaziz City for Science and Technology for patents. But in 2018, the government of Saudi Arabia established the Saudi Authority for Intellectual Property in order to be the sole competent IP authority in Saudi Arabia, with the responsibility to regulate and support and protect and enforce and upgrade the fields of intellectual property in the kingdom in accordance with the international best practices. Saudi Authority for Intellectual Property is also responsible for proposing the new rules and regulations relating to IP rights to ensure the national legislation keeps pace with the rapidly evolving global technological enhancement. Another thing, if we need to talk about the patent services that the Saudi Authority, SAIB, provides, they are many, including the filing the application, making amendments, transfer of ownership, and adding power of attorney or assignment document and registration of license. Now I need to talk about briefly about filing application for patent registration with Saudi Arabia for intellectual property. There are 2 routes for securing protection in Saudi Arabia. Whether the applicant is needed to file an application with Saudi Authority for Intellectual Property in order to secure protection only in Saudi Arabia, or to file an application with the GCC Cooperation Council in order to secure the protection in the 7 Gulf states, which is Saudi Arabia, Bahrain, Qatar, and UAE. First of all, it should be noted that the online system of the respective patent office provided the online registration of the application. The application is to be filed in both languages, English and Arabic, in order to be accepted electronically. After filing the application is to be examined in order to comply with formalities and subject. If there are any deficiencies in the formal documents, the applicant will be asked and requested to complete the formalities. And if the formal examination has passed the examination, the applicant will be requested to pay the publication and examination fees in order to initiate the substantive examination process in terms of the three criteria of patentability, which is the novelty, the inventive step, and the industrial applicability. If the patent application passed the whole examination process, which is the formal examination and the substantive examination, then the patent application will pass to registration and to a grant process. In this case, the application will be granted and obtained and a letter is a patent. In this case, it should be noted that the term of patent protection is 20 years from the date of filing, and also that the patents are territorial in nature, and any registration outside the Saudi Arabia does not grant registration nor secure the protection in Saudi Arabia. In terms of statistics with the Saudi Authority for Intellectual Property, we obtained yesterday such a number of filed orders in terms of trademark registration and patent filing application, and also industrial designs. Also, we obtained through the online system of Saudi Authority for Intellectual Property some numbers and total number of patent application filed with SAIB, and also the patent certificate issued up to date. For patent registration statistics in the GCC Patent Office, we also obtained through the online system number of patents filed through different IB fields and through different topics: chemistry, chemical engineering, pharmaceutical and petroleum, and also mechanical and electrical engineering. When we made a study for the report for the half year of 2022, we noticed that there is a growth in the number of patent applications filed and registered for the same period, and the growth was with the percentage of 37%. Okay. Now I would like to talk about the most important recent changes and updates in Saudi Arabia. The most important thing is the implementation mechanism of patency with the Saudi Food and Drug Authority, SFDA. SFDA issued a new set of regulations and the processes where generic pharmaceutical manufacturers are to provide SFDA with a freedom to operate study signed by the IB Council in order to register the generic medicine with the SFDA. The IP Council must be a registered agent with Saudi Authority for Intellectual Property in order to be able to provide SFDA with such a study. Such a study must be accompanied with a declaration and an acknowledgement that formula does not infringe on patent rights, and this new regulation entered into effect on 3rd of January 2023. Saudi Food and Drug Authority published officially the mechanism of dealing with patents when registering the generic products with SFDA, with the main objective is to enhance confidence in the guidelines for patent registration of pharmaceutical products and facilitate the procedure of registering generic pharmaceuticals with SFDA. Now I need to talk about the procedures adopted for the generic company to register a generic product with SFDA. SFDA will request the generic company to submit, as I mentioned, a freedom to operate study with an acknowledgement that this generic product does not infringe any existing patent with Saudi Authority for Intellectual Property. The generic company in such cases or in some cases is not required to submit such an FTO analysis when submitting the product registration with the SFDA if there is no patent protecting the originator product in Saudi Arabia. In this case, SFDA will accept the registration of the generic product. Also, there is a right for the generic company to submit an application to register the generic product with SFDA 6 months before the expiration of the term of the patent, but on the condition that marketing of the generic product will not be permitted unless after the expiration of the patent term. Also, the SFDA outlines some requirements for registration of an innovative product with SFDA for originator companies if they have a valid or pending patent in Saudi Arabia. First of all, the originator company must submit a copy of the patent of their innovative product issued by Saudi Authority for Intellectual Property in the product registration file submitted to the SFDA. And in case that the valid patent has not yet granted at the time of originator company submit this product registration application, then the patent shall be submitted within 30 days of its issuance. If the originator products that are already registered at the SFDA and protected by a valid patent issued by Saudi Authority for Intellectual Property or GCC, I mean in Saudi Arabia, then the originator company must submit a valid patent to the SFDA within 30 days from the publication of this implementation mechanism of patency. In case that the originator company believes that this generic product infringes over its KSA patent, in this case, the originator company has to file a claim at the commercial courts in order to obtain a judgment in its favor and in order to request the SFDA to cancel the registration of the generic product.
Quickly jumping into
Another update which The another updates in Saudi Arabia is the entry of Hague Apostille Convention in Saudi Arabia. The Apostille Convention officially entered into effect in Saudi Arabia on 7th of December 2022. In this case, it is accepted by Saudi Authority for Intellectual Property to have the, let's say, formal documents of patent and other IP rights to have been apostilled, rather to be duly legalized up to Saudi consulate. And from that date, contracting states or parties are obliged to waive the legalization requirement for public document issued by Saudi authorities, and likewise also Saudi authorities must accept apostilles for the incoming foreign public documents issued by the competent authorities of other contracting parties. Okay, the third main updates with the GCC in Saudi Arabia is with the GCC Patent Office. As you may recall that the Gulf Cooperation Council GCC Patent Office stopped accepting a new patent application filing since 6 January 2021. And in this case, our recommendation to the applicant who are targeting the GCC countries was to file applications separately in each country of the Gulf state.
Sorry that I
Right.
jump in, but final remark, please, Shadia.
Again,
Sorry to jump in here, but please final remark now as we are running out of time.
okay. Okay, by this new implementation regulations published with the GCC Patent Office, the system of the GCC has been converted from unitary GCC system to country designated system. In order not to go for each slide, I will jump for the final slide, which is the Patent Office GCC has published on 1st of December 2022 that it will receiving a patent application and conducting the formal and substantive examination on behalf of Kingdom of Bahrain and State of Kuwait. Thank you.
Thank you very much for that precise presentation. And already some questions came in, Shadia, for you. Same like we had for Mohammed with regards to the digitalization. So how digitalized are the IP system, and is the patent filing system done on paper or via the online tool?
Yeah, as I mentioned in my presentation, also all patent applications and design applications is filed with Saudi Authority for Intellectual Property through the online system, and no need at all for the paperwork.
Perfect. The next question is with regards to trademark. Is it possible to register a sound mark in Saudi Arabia? And if yes, what is the requirement?
Okay, because my specialty is patent, so I can answer this question by converting to one of my colleagues later on, because I don't have any further information regarding trademark registration.
All right, thanks for that, and then providing it later on. And then we have one more question. Thank you for the discussion of the SFDA's new patent linkage procedure for pharma patents. Is there a procedure to provide current patent information for products that have already been registered in Saudi Arabia?
Okay, as I mentioned, that if the originator company finds that the generic product which need to be registered with the SFD authority will infringe its originator product, it can file a claim before the court in order to ask the SFDA to cancel the registration of the generic product. Yeah, there will be a procedure before the courts. Yeah.
Lovely. So final question, if you are in the position of the applicant or the inventor, would you continue to pay annuities and different recorders for the field GCC applicants if your budget is tight, and keeping in mind that some countries do not consider GCC applicants enough for enforcement?
Regarding the payment of annuity with the GCC Patent Office, the applicant is obliged to pay the annuities up to a third annuity. And after the grant of the patent application, he is have the right to postpone the payment of the annuities of the GCC patent application after a grant. So he is obliged, and it is mandatory to pay up to a third annuity, and the other annuity can be postponed after the grant of the application.
Lovely. Thank you so much for answering. Now more questions are coming in, so that is great. Thanks a lot for your presentation and for answering all the questions.
Sorry again for inconvenience for the technical issue. I hope that every information is given very clearly.
Absolutely. Thank you very much, Adia.
Welcome.
Thank you, Judith. And again, thank you, Shadia. Saudi Arabia is a very important jurisdiction for many. So thank you for being so detailed in that. Next and last but certainly not least, we have Mr. Munir Subah, who's representing AIPPI UAE. Munir is a partner and head of IP at BSA law firm in the UAE. With over 15 years of experience in IP in the region, Munir's main area of practice is in the field of IP and media, including trademarks, copyrights, patents, trade secrets, domain names, media advisory, regulatory compliance, and representing clients in contentious matters. Please go ahead, Munir, share, and we look forward to hearing from you.
Thank you, Huda, very much. Very good evening to you all. Very late good evening to Mr. Okayama. Thank you very much for the introduction. Thank you very much for being with us today. It shows how important is the Middle East for the AIPPI community. On behalf of my colleagues, peers in the UAE group, in behalf of the board members and all the committees of the IP in the UAE, which is, I think, the youngest in the region that was established just a few years ago, and having the president of our national group, Huda Barakat, with us today to moderate this session, to just give the value and the weight for this. I really thank my co-panelists for all their informative and very great presentation that they gave on each of their jurisdiction. I will try to wrap it up tonight for you, giving you a quick update on our presentations and our position in the UAE. But last but not least, I want to thank AIPPI member for all of their hard work to set up this and to bring all this great turnout of all the members and all the audiences. Pretty much I think the slides is clear now, is perfect. Okay, we'll try my best today to give you a quick update within 10 minutes on all the developments and updates. I'll try to share some statistics as well, based on the available information. But in a brief, this is the few topics that we will be covering today, from legislative landscape and what is the recent updates that happened in the last couple of years. I will also cover the treaties and registries, some of the treaties that we have it applicable, and we'll go through all these subtopics in a few minutes. If you have any question, feel free to put it there, and I will be more than happy to deal with it at the end of my slides. The quick update, I mean, the UAE is a federal country, as probably most of you are aware. It is one of the most dynamic and most important economy in the region. The country is federal, but the regulator, the legislator, is very reactive and very prompt in terms of dealing with all the challenges. So in 2021, the entire legal community was pretty much aware of all the updates that happened in the legislative backgrounds and the legislative platform. More than 50 regulations and federal law and decrees were passed to amend or repeal the old laws, and IP took a major chunk of that. I mean, the IP regulations, whether it's trademark, copyright, patents, industrial properties, and so many ons, and trade names laws, all of these regulations were revisited and they were enacted along with their implementing regulations, which were following in 2022. I'm not going to go through each of these regulations, but it's just some of the most relevant laws that were enacted in the last couple of years, and they have been published and made enforced in the last 12 to 24 months. Fortunately, AIPPI UAE National Group is making a great impact on those things, and a lot of our senior members, including board members or some of the senior IP practitioners that were part of these discussions, they were able to give their inputs. They were part of the consultation scheme when we spoke to the regulators, and as an advocacy group, we were able to make our voice there and to make this regulation look more modernized and more up to the international standards that we all are hoping to see in the region. In a brief, quick updates, there are some registries and some of the treaties. I'm not going to touch on the treaties because most of the international treaties that you are aware of, and you heard it from my previous co-panelists, are there and implemented in the UAE from the beginning of this millennium, some of them before that. But in terms of registries, we have 3 main registries that deal with the registration of trademarks. They're still the same. There are no changes on their setup, whether it's a trademark or a patent office or a copyright office. They are all under the umbrella of the Ministry of Economy, the UAE Ministry of Economy. We also have the custom registries, which is, again, it's not relevant. It's not connected to the Ministry of Economy, but it is an independent registries that each customs authorities decided to have it and implemented. Not all of the customs authority in each of the Emirates have one, but at least the core Emirates and the main Emirates, they have developed an IP recordal system where the IP brand owners or the IP owners can move and record their rights and get a customs protection against any of the counterfeiting or piracy products that could be imported to the UAE. Trade names registries, it's part of, again, a local registries where you have it in the DED or the economic departments. And I'm going to speak more about that authority, but it is the regulatory authority in each emirate that deal with the setup of companies and a corporate, and they have within their own records, their trade names and their own registrations for each company based on the desire and the request of the company's owners or the shareholders. Unfortunately, those trade names are not synced, are not related to the Ministry of Economy. So that's created a lot of issues in practice in terms of conflict between trade names and trademarks. There have been a lot of great movements on that, and the recent regulations that were enacted in the UAE deal with this issue and put some expedited measures when this conflict exists on how it should be resolved. One of the unique things that the UAE has been doing in the last year and last actually 12 to 18 months is to focus more on FTAs, having federal trade, free trade agreements with selected partners from all over the world. As far as I know, there are more than 20 agreements and treaties are being discussed on one-to-one bilateral basis, but also there are some agreements that are being discussed and negotiated on regional basis. For instance, nowadays, we know that the UK is negotiating with the GCC countries as a whole, an FTA that could be put in place and signed. The good thing about the FTA, there is always an IP chapter where parties commit for a certain protection and certain measures to be implemented and approved. But again, as I said, there is a lot of bilateral agreements signed since 2020. Some of it were signed with India, one of the largest economies in the near Asia, in the world actually. And they have a great trade volume with the UAE. An agreement was signed with Israel, Kenya, Indonesia, and more to come on the way. And they are very selective as a country to pick the countries that could make a good impact and a bilateral trade and commercial relationship with the UAE to improve the trade in general, but also the IP is taking a major part of the discussions and negotiations. Again, as a member of AIPPI UAE group and as a member of advocacy group, we always have a chance to speak with the ministries or with the decision makers to give our thoughts, to share our knowledge, to share our experience with where other countries have negotiated these FTAs and they have the chance to improve the IP practice and improve the IP measures. And the good things about FTAs, if you commit to one of the IP measures and with any of the states or any of the treaty or any of the agreements, you by default give the same privileges for the rest of the members. So it is always a good way and a good tool to improve the IP measures and IP policies in any of the countries that are member with FTAs. In a brief, there are recent changes. I will try to take you through each one of them in bits and pieces in a few minutes in trademarks, copyrights, and industrial property law. Those are brief. They're there slides. Once you request them, you should be able to just go through each one of these comments. But in a brief, these are the 3 fields I'm going to focus on in the next few minutes, just to give you a quick practical updates on things. If you have an interest in the UAE, you might need to be aware of it. The law of 1992, which was the first law that was there for trademarks, is no longer there. Now the new law is in 2021, and the implementing regulation was just passed 2022. One of the key changes and the updates that we've seen it in the trademark domain in general, the scope of protection, the trademarks has been defined broadly. We start to see a lot of good modernized definitions of the trademarks, such as the hologram trademark. A question came about the smell trademarks. It's already there. The mechanism or the sounds of trademarks, it's already there. It's recognized, and the trademark office is obliged to find a mechanism to deal with the registration of that process. The well-known trademark is being defined very extensively based on the court practice and based on the international best practice. More criteria to look at the well-known trademark rather than just having the traditional definition when it says that it should be a trademark that is known for the consumer beyond the country of origin. So more than that has been put in the law, and more regulation, more clauses and articles to define and to deal with the well-known trademarks have been introduced in this new law. GI has never been regulated before. Again, as part of the international best practice, GI is being mentioned. There is a chapter in the trademark law at the federal degree that was passed in 2021. It deals about how the protection should be done, a special registry should be established, and what are the situations where GI should not be registered. This is a very useful piece of articles to have it in the law of the trademark, as there's a lot of confusion has happened in the past where we've seen a lot of GIs were registered improperly as trademarks. The registration timelines, bizarrely for the first time, has been put in there in the law. We don't see that very usual in the region, but it seems to be that the legislator wants the trademark office to function very promptly and according to best practice. So we start to see a 3-month period is mentioned in the law as a normal examination time frame. So trademark applicants should expect an expedited examination. Cancellation appeal formalities, there have been a specific change in the law where there is a committee has been established and a sort of a grievance committee, and this committee should have a judge as one of the members, and this judge with the 2 members that is being appointed by the ministry can issue a resolution or a decision, and this decision is pretty much equivalent to what you see in the first instance court judgment. So their decision as an appeal committee should be challenged directly to an appeal court. So this could assure an expedited process, and there is a dispute, and it also can relieve the first instance court from receiving all the cases that they used to receive it in the past. Accessation of Madrid system, everyone has been aware of it from the beginning of 2021 in the UAE, and there has been an increase of penalties and sanctions, which was a very useful change in the law that we have seen it. So we start to see up to 1 million dirhams of fine penalties are being imposed in the case of counterfeits and in case of infringement. In the trademark prosecution, again, as we've said, there is 90 days examination time period. I mean, in practice, this is mentioned in the law, but in practice, in the past, before we entered Madrid, we used to see the trademark office examining marks in a very quick basis. Within 1 month period, 2 months max, a trademark could be examined and published. After accessing Madrid, after the change of the law, we start to see some slow movement in that part, unfortunately. I hope it's a temporary issue where we're going to reach to a point where we'll start to see the examination time frame is on an expedited basis and as per the law, which is 90 days. The publication of trademark and the publication of accepted trademark, it used to be happening as a once a month. Now we start to see 2 releases of the Gazette happen every 1st and 15th of each month, a day or 2 days before and after, which expedite the process of the prosecution in general. So these are some of the changes that we have seen it in the law. Multi-class application is still not applicable, but in the new law, we start to see we had a clear provision to allow the trademark office to receive multi-class application, which it's going to be very useful for the trademark applicants. But still, we need to see more how they will deal with this clause and how they will deal with the formalities in terms of official fees and all the rest of the details. Some good news we start to see about the assignment process. Assignment of pending application is acceptable. In the past, it used to be not possible. In the publication, there is no longer a requirement to publish a trademark in local newspapers. Only an official gazette is enough. All of these new modernized process and changes in the law made things much easier and less costly to some extent on the applicants to get the registration funds. The good things about the recent practice, we start to see a very good positive attitude from the trademark office and examiner when they start to receive applications from applicant in the field of the Web3, Web3 with whether it's in the cryptos or NFTs, even applicants and companies that they want to protect their interests and assets in the metaverses. So we did not see a very major challenge to have those items filed and registered under the traditional classes or under any class of their interest and their choice. And that's a good thing about the flexibility of the examiner, where they don't really follow a standardized list of services or goods under the international lease classification. One of the
2
most
more
important
minutes for you, Mini.
Sure. So Madrid system, we entered it, we have it. The examination is going very still at the trial phase, if I put it this way. We opted for the 18 months period. We still don't see local publication of the international application. So I feel that there is a lot of works to be done until the Madrid system is fully integrated within the local system. In terms of the copyrights, I will touch base on this very quickly. We start to see some changes on the future assignments. In the past, it was not allowed to do more than 5 assignments of works. Now it's allowed up to 10 works. There is an increase in penalties in terms of piracy and infringements of copyrights and so on. Work for hire doctoring is the first time is introduced, and it's clearly mentioned in the law. It's allowed that in Article 28, when there is at work is done for the benefit of another, there is an automatic assignments for that unless agreed otherwise. Fair use is being regulated in a more comprehensive way, and it is something that has been really welcomed by the IP community. In terms of industrial property law, or known as a patent law, there is also a changes on that one. What I could say is there is an option to go for an acceleration examination. There is an introduction for a grace period, so absolute novelty is no longer a challenge for the applicant. If the invention is published within 12 months before the application, it's okay, you still have the chance to file it and register it, while this was a major challenge for the patentee in the past. Utility patent, utility certificate can be converted to patent as well. And also the design registrations went to 20 years from the date of application, which is also a change from the past where it used to be 10 years subject to renewal. A recent update happened in the prosecution, just very recent. It was orally conveyed to us that the patent office will go very lenient with the formalities and the documents. Power of attorneys do not need to be legalized up to the UAE embassy. We don't see any requirement for assignments document to be also legalized, and authorization will be just enough. This is a very good progress. We received it as an IP community directly from the patent office. Also, supportive documents no longer need to be translated to local language unless it's required. Those are all changes are being taken by the offices just to make sure things are moving very well and up to the international best practice. In a brief, I will take you through quick statistics that we are aware of. GDPs is one of the highest in the region. In the UAE per capita, it's probably the highest. But overall, the GDPs as of 2020 was 662 billions. Now it's probably around 800 billions or more. And this makes it one of the top 3 or 4 countries in the entire largest Middle East, if we include Turkey, Iran, and other countries that have more populations and resources. Patents, there have been some patent applications. We've started to see some good improvement in force in 2021. These are the numbers. They're just there. Is still more. The patent office aims for more numbers to be registered and granted. So hopefully we start to see a more progress on that in the coming years. In terms of trademarks,
please.
Yeah. Final remarks, trademarks. Also, we're going to put the statistics. Unfortunately, in 2022, we still don't have the numbers, but we've witnessed drop down, and that was a very normal one after the Madrid system was implemented. The statistics of customs and all the enforcement. These are there. We don't have a federal resources on there, so we believe that the statistics can be more useful when we're going to get one source of information. In terms of enforcement, I list down those all enforcement options. We have them in the UAE. You can also look at them, and we can have a follow-up questions. And in conclusion, I will put this as a very final words. The IP system is advancing overall, and there are still more and more to be done. Registries are improving in their formalities, and enforcements remain as a challenge, but it needs to collective efforts, and people from AIPPI and people from all the international community can work together to get this done. At the end, I want to thank you for being here, and I'm more than happy to take any of the questions. Thank you.
Thank you very much, Munir, for that. And sorry to stop you on that, but
Absolutely.
I also see some questions, which I think is worth it to take into account. So the first one is that that person has recently noticed substantial development in enforcement taking place in other small emirates. Do you see this trend continuing? And could you highlight this matter in a brief?
Well, the enforcement is a key challenge for all the IP community and trademark owners, not only in the UAE, but the entire region, and it's globally. And the more we go online, the more we see an efforts to be done between online and offline. Now, when you see the different emirates, I mean, I assume you say, I think, other than Dubai and Abu Dhabi, those emirates are very ambitious, very willing to improve and to work with the brand owners. It's a joint responsibility between the brand owners and those officials to continue these efforts, to pick up the momentum and to try to continue these dialogues. I don't see any reason for them not to continue to work with the brand owners. And I see the problem is occurring in those territories for many logistic reasons, commercial reasons, but also because the law enforcement is still at the pickup stage where they want to set up a proper enforcement system. So I do believe that it will continue, but it will not continue by itself. It will continue with the efforts of the brand owners and the IP owners.
Right, thank you. Then a question, is it possible to file any amendment on patent after grant stage?
Well, okay. Granting is not actually, it's the start to, I mean, if you ask me this question like 10 years ago or 7 years ago, probably the number of the granted patent were just very minimal. Now we start to see more and more granting. There is no, in terms of limiting the protections and the claims, there might not be a problem of doing that. But to expand on the patent itself, I'm not aware if the patent office will accept that request or to move with claiming more protection. So depend on what type of amendments you're willing to do. If you want to amend like the address or do something in formalities, they could be receptive of that. And the good things about the patent office here, they are always evolving and they're always improving with their formalities. So if something can come even after the filing or within the examination or even after the granting, that could not that could be justified. I don't see any reason for the patent office not to accept it.
Right.
I personally have not amended any patent after granted. So all what I'm giving you is a theoretical answer.
Okay. Final question then. Does all the design application filed after December 2022 will protect for 20 years instead of 10 years?
Yes, the duration for the designs from the filing date is 20 years. So anything that was passed after the 2021 law was enacted and the implementing regulations, it should not be problematic to, I mean, it should be for 20 years. Yeah.
Okay, then final question came in. Has UAE become a member to the Apostille Treaty?
Unfortunately, I'm not aware that this is something is happening now and it's not a part. I would love to see that. I would love to see UAE is part of that because it is actually more than 122 members are there already or 121 members already there. It will actually relieve the brand owners and the IP owners from so much of formalities, but I'm not aware that this is happening now, but it could be subject of discussions or consideration by the decision makers. But as of this moment, they are not part of it like what the KSA did.
Okay. Thank you very much, Munir. So final remarks then from me, and I start with a thank you to the whole team with whom I worked with for the several months now. It was, I must say, a pleasure from start to end, and a big, big thank you to Hoda and Motassem, with whom I started with the initial calls, but then due to your leadership in taking that on, we made it into today's session, which I think was very much appreciated by the audience. I certainly enjoyed. So thank you very much, the two of you, for taking the leadership on. The next thank you goes obviously to the speakers in taking on the challenge, preparing the presentations, preparing the slides, being challenged in finding some statistics, which we found, I think, very relevant. And you assured that it was not that easy to find them, but you didn't give up on that. So thanks a lot for putting this effort together and having such a successful Scan the Globe session. Then obviously, finally, to all of you participants joining this session, that makes it as a success. It seems that Middle East has got traction, has got interest, that people want to join and want to learn more from the Middle East and from you. And so the presentations are available on demand afterwards. So any material which is then relevant and you want to look up finally. So then with this final words, inviting you to join the Istanbul Congress, which is upcoming in October 2023. So the registration will open on the 9th of May. We're starting our preparation, getting excited for going to Turkey for the AIPPI Congress in 2023. With this, closing the session, have a good rest of the day, and thanks again for your contribution and participation.